I prepared my coffee.
Okay.
And then totally forgot that I had done it. Water. Change a filter, filled up with grounds.
Okay.
Hello.
Hello?
Yeah.
Hello?
Hi, Megan.
How are you doing, Mark? Hi, Michael.
Hi.
Oh, I haven't seen that view of your house. That's a good one.
Ah, wow, there you go.
Almost now I've got the full tour.
How many people are we expecting?
Hello.
on the thing?
Vicky, do you have a sense how many people we're expecting?
There were 27 people that signed up. And
Great.
so streaming it to, streaming it to Facebook, we get a lot more people that way.
Great.
I was watching the numbers. They were huge for Facebook Live streaming. That's great.
Mm-hmm.
Can you hear me okay?
Yeah, you're a little quiet, maybe a little louder. Turn up the volume.
I don't know how to do that.
I can hear you just fine, Mom.
All right, good.
Great.
He has better ears.
Has anybody talked to Steve?
No, I just got his email. Did you see my email that he couldn't find the email?
Ay.
Mine's
I'm
been going to
available
spam.
He says, I'm available. How do I get on?
Yeah, I know. He is. I'm gonna send it to him again, and then I'm gonna text him because
Oh, thank you.
we had the same issue the other day when he was supposed to be on one for the ADA.
Okay.
He couldn't figure out how to get it on. He was getting very
Good.
flustered about it.
Yeah, you would think. We talked yesterday that he would have kind of practiced, but so I just told him you were going to be in touch.
Yes.
Okay.
I just sent it to him again. Hopefully it's in the very beginning of his email. Now, let me.
Okay.
Just remember, Michael, whenever you're talking, you can be heard, right?
Yes, but I was asking.
Right, I was trying to rename us, but I can't seem to do it. Be Mark
Well,
and Michael.
it's under Mark Anderson. That's okay.
I can do that. Hold on 1 second.
Let Vicky get Steve.
That's fine.
Megan,
Mm-hmm.
because I'm using the iPad, because Mark and Michael have my computer, I cannot read the chat. Do you want to do that?
I can do that at the same time. Yeah.
Okay, thank you. And I see your little kitty.
Yeah, I'm gonna cut my screen out when we get started because that cat is gonna be all in my deal. for
It'll
this
get
whole
people to pay attention.
We've been getting people. We all week we've been cat bombed.
It's part of the excitement. You lose that, in person. It's a new excitement on Zoom. Hi, Rachel.
Hi.
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 Sorry, ladies.
That's okay.
I fell asleep last night. I was so exhausted after the last event.
Vicky, I can't believe that you haven't been falling asleep at like 8:15 every night because you're working very hard.
Yes.
Yes. I unfortunately am not.
Oh.
But last night I fell asleep and I must have needed to sleep because I heard nothing until my boyfriend was like, you know what time it is? And I was like, "Hey." I was like, I gotta get up.
Yeah,
Vicky, can you
totally
switch-
understandable. Sorry.
Can you switch me over to host so I can share, or can I share my screen right now? Let me see. Oh, I should be able to. Okay, good.
You want to practice? There we go. There we
There we
go.
go.
And I'm going to turn my video off for a minute. I will still be here.
I'm doing the same. Sorry, guys. Cat show's over.
And I will too, but Michael and Mark, you keep your video on, okay?
Mhm.
All righty.
Have you, I can't seem to get Steve.
Ugh.
The phone number I have for him, I'm not getting him to answer.
I'm not even sure I have it. Mark, do you have Steve?
I
Oh,
have it in an email.
all right, I have two, Vicky, I have 267-546-1307.
1307?
Yes.
Okay, I'm gonna try him.
I have a different number.
Okay.
What do you have?
It might be changed. I have 215-498-0689.
Right.
Okay. I'm gonna try one of those. See if I
If not, I'll just go on without Steve.
Yeah.
No.
Let me see. Chat. Here's the chat. Okay.
it's very frustrated.
All right.
So Mark, do you see the chat feature?
I do. It says chat. Yeah, and there's one little chat. Welcome all. That's Megan.
Okay. If you need anything or need help, Megan is there to help you. And you can type a question to Megan, okay?
Right, something like help.
Yes, something like that.
Oh, okay.
Let me see if Steve's.
Mark, are you able to talk?
I can now.
Good, okay. I just saw that you were muted and I was getting a little,
Just muted myself because didn't have anything to say. And,
that's okay. Just wanted to make sure you could speak.
Okay, so it looks like the number that Mark had is his phone number, but he's not answering.
Well, if Steve doesn't do this, Mark can do it. Mark
Okay.
can take Steve's. Do you want to send him an email then?
who are you
Send,
talking to? Vicky?
Send Steve Gold an email with the log-on information? I know you already.
I just did right before I tried calling him. Because I was
Okay,
saying,
Okay.
let's go into your email and kind of like open the email up. All you gotta do is scroll down to the blue letters.
okay, that sounds great.
But I can't get him on the phone to do that.
Did you try typing?
Vicky, if he joins in halfway, he'll be able to jump in. if we get started, right? He could still log in as a presenter if he got here just a little late.
Yeah, definitely.
Okay.
Did you try texting him at the phone number as well?
I did not text him. Sorry.
Might try that too.
Okay. Because I am.
Doing a million other things?
I'm trying to get the name. I'm trying to add Michael's name.
Oh, don't worry
that's
about that. Don't worry
Don't
about that.
worry about that. Don't.
That's okay. I got it.
So you do. Would work.
Yeah.
I like to make sure that they're the right way. So,
Vicki,
yes.
I'm going to start today.
Awesome.
Will you guys be switching, or will we need to kind of stop at a point? Will you send a message? What's the best way you guys are handling it?
I'm sorry, can you just say that one more time?
Are you guys going to be notifying the presenters of when you're switching, or just doing it as?
We'll just do it about every
Okay.
15 minutes, and honestly, you'll just see Jay pop up on the screen,
Perfect.
and when there's a natural break, we'll just transition to the other interpreter, and Vicki's been handling she's been
Good.
spotlighting, I'm not sure what the right word is,
Yeah.
pinning us to make sure that we're visible.
She's doing a great job with that. Thank you guys
Yeah.
so much.
No
okay.
problem. No problem.
All right.
I'm getting it set up on Facebook. Excuse me. My allergies are not participating with me today.
Megan,
Mhm.
how are you going to change the slides? You want us to tell you, or?
Yes.
I would like you to say next slide, and then I can move it really
Sounds
quickly.
good.
So I'll wait to hear you say that and then move it. Mhm.
Okay.
Good
So
question.
Mark,
Yeah.
if Steve is not able to join, you need to fill in all of it, okay?
Gotcha.
Yes, and don't be worried that you have to be like a whole hour long. This is, talk for as long as you need.
Okay.
And I'm going to, since Megan's there doing a wonderful job, and then you already have Jay and Rachel, I'm going to mute myself because I don't think you'll need me. Okay?
Okay.
All right.
Come on, catch a video stream. Hurry up.
Mhm.
Sometimes it takes just a minute for it to grab it. I turn down my phone. It's one thing I always forget to do, and then my phone rings at the most inappropriate time. Come on. Okay, there we go. It works. Okay, so we're going to go live in 5, 4, 3, 2, 1. Hi, everybody. Thank you for joining us for another event for Disability Pride Virtual PA. Today, I'm honored to be to have the floor I'm sorry, my words are not there today. Hello. Today we're honored to have Mark and Michael Anderson. They're going to be talking about advocacy under the ADA of the Anderson versus Franklin Institute court case. Thank you. Hi, guys.
Hello.
Hello.
Good to be here.
Good to be here.
Good. The show is all yours.
Okay, so
Well, Megan,
my name is Michael Anderson, and this is my dad, Mark.
Yeah,
And
we were going to have a little introduction, but
gonna
we'll
have-
just go ahead.
Just proud right ahead.
All right, first of
So
all,
I went to school up at Edinburgh State University, which is 8 hours away, 6 to 8 hours away, depending on how fast you drive. So I wanted to go back home after graduation, join some membership, join some museums. So this is one of the museums that I joined.
right. So next slide, please. Yeah. So we're going to introduce, first of all, a little bit more. So Michael, as you can see, there's his graduation picture coming from Edinburgh. He got his associate's degree in 2008?
2007.
Oh, 2007.
And I wanted to go.
Okay, and I'm glad somebody remembers. Okay. So anyway, Michael, I'm Michael's dad, and so my involvement in this story is primarily as
A legal counsel, I guess.
my role in this story is primarily as his father, although I do have a legal background. I've been was a lawyer in private practice for a number of years up in Boston, and then I moved to Philadelphia to become a law professor at Temple University. And so that's my current job. But anyway, I know what I know about disability issues. I mostly learned because my son Michael has a disability. What exactly is your disability?
Spastic quadriplegia with dystonia, cerebral palsy, but my exact diagnosis is spastic quadriplegia with dystonia.
All right. Now, of course, the reason that this is significant is because
I need 24-hour care because I can't feed, dress myself, or do anything physically.
Right. Today, Michael's in his manual chair, but that's because his power chair is currently on the disabled list. But normally, he drives himself around in his power chair. But otherwise, all the other activities of daily living, eating, dressing.
I need 24-hour assistance with, and so that's why I have an attendant go with me to the museum. So
right.
You can go over that there.
So, right. So the reason that's important is Michael never goes outside or goes anywhere outside of his home without an attendant. And so, go ahead, next slide. So anyway, after he graduated,
I was getting Edinburgh sick, so my parents said, oh, what can we get him to do without losing his friends, without being Edinburgh sick? So they decided to get me memberships to all the local museums, and one of them was the Franklin Institute.
Right, but we also had memberships at the zoo, at the art museum, and some of the other museums in town. So anyway, we
originally had a dual membership,
right?
But then we switched it to single one.
Right, but so we had a dual membership, and so that was so he could have friends with him. But what we didn't know is and mostly he just went by himself with his attendant.
And with no friend, but they counted my attendant as a friend, but they shouldn't have done. But you can tell this story.
No, that's okay. All right, so next slide, Megan. So anyway, so one day, you tell the story.
One day, how far back do you want me to go?
The time when you got rejected.
Oh, so my mom said the original story was my mom gave me enough money for one person, and my mom said, where did my money go? And I said, well, my attendant team is in charge for my attendant. So my mom said, go back there one more time and explain to your situation. So I did that, and I had my mom speak to a supervisor, and they said they wouldn't let them in for free. So my dad called the
Right.
ADA hotline.
No, all right. So yeah, so we were really surprised because previously he had gotten in without having to pay for his attendant. And they said, no, the attendant has to pay. And so on that particular day, Michael spoke with the supervisor, and so did his mom, and they all said, no, attendants have to pay. And so I actually called up membership services because it didn't seem quite right to me.
And we said, can we have it in writing?
I called membership services, and so they said, yeah, that's our policy. You have to pay for attendance, and whether they're going for general admission or special exhibits or the IMAX movies that they have at the Franklin Institute, everybody has to pay for themselves. And so I didn't think that was right. And Michael, I know you didn't think that was right.
I didn't think that was right. So we called the ADA hotline.
Well, anyway, so first of all, why did we think this was a potential violation of the ADA? Next slide, please. So I thought it's useful to look at some of the language of the ADA. Obviously, it's a fairly complicated statute. There are a lot of regulations, but our claim was pretty much based on the straightforward language of the statute. So it says, no individual shall be discriminated against on the basis of disability in the full and equal enjoyment of the goods, services, and facilities of any place of public accommodation. So a museum is defined by the regulations as a public accommodation, just like baseball stadiums, movie theaters, zoos, parks, restaurants, et cetera, et cetera. And another part of the ADA says it shall be discriminatory. In other words, what does it mean to discriminate? To afford an individual with the opportunity to participate in a service that is not equal to that afforded to other individuals. Right. Next slide, Megan.
And we thought that was.
All right, so here.
So we went to the ADA hotline.
Well, you keep wanting to get to that ADA hotline, Michael.
Okay.
No, that's coming. That's the slide after this one. So why do we think that this policy of charging attendance is discriminatory and denying equal treatment?
Because I can't go anywhere without an attendant.
So number one, Michael has to go take an attendant to go anywhere. Unlike most people or people without a disability who can go by themselves, Michael has to bring an attendant with him. Now, when attendants come, they're working, they're on the job. And
they can't, with their salary, they can't even afford their own admission. So it's like I have to pay double out of my own wallet.
Right. Well, and even if they could afford it, it's like, hey, I'm not getting paid extra. They don't give me expense accounts or anything. So that would just come right out of their salaries. And so you can't expect them to pay for themselves. And so Michael, as he said, if he has to pay, that means that he has to pay double. He has to pay double. So we felt that he was not getting a service that was equal to that afforded to other individuals because he's paying twice as much. So if it's $15 to get in the Franklin Institute for an individual, how much are you paying?
I'm paying $30.
$30. That's right. Okay. So that is not equal treatment. So that was our thought. Next slide, please.
And now we go to the ADA.
Oh, almost. So anyway, we asked, went to the membership supervisor, and as I mentioned in that previous phone call.
And they said we can we'll bring it up to the board, and then they send us a letter.
Confirming, they raised the issue with the board of directors of the museum, and their conclusion was that the attendants had to pay just like everybody else. You can't get something for nothing. So we got a letter from them saying attendants would have to pay for general admission, and then for special admission to special exhibits, and then for IMAX movies and things of that sort. So it still didn't seem right. So we thought, well, let's call our government, right? Let's talk to the United States Department of Justice. And so they have a hotline, and it's staffed by attorneys. And this is also, we're talking maybe 2013, 2012. So it's in a period where we would expect the Justice Department to be reasonably responsive. We won't necessarily go into who was in charge, but Michael's always already given that one away. But so anyway, I called him up and I said, here's the story. My son wants to go to a museum. He has to have an attendant. They want to charge him for the attendant as well as for himself. Is that in compliance with the ADA? And the attorney said, well, yes, it is. And I said, well, how can that be? And they said, well, we have a test that we've got. And the test is, does the attendant benefit? And I said, well, what do you mean? He said, well, I'll give you an example. So he said, let's say that your son wants to go to a swimming pool. And so he brings an attendant along. So let's say the attendant accompanies Michael to the dressing room and gets him dressed. And then helps push his wheelchair to the edge of the pool, and then gets him out of the wheelchair and puts him in the water. And then he just stays, by the side of the pool while Michael swims. And then, he pulls him out and puts him back in the chair and changes his clothes and they go back home. There, the attendant would not have to pay because the attendant did not benefit from the service of using the pool. However, if the attendant gets in the water, then the attendant is benefiting, and now the attendant will have to pay.
But we thought this was ridiculous.
Well, it's ridiculous because if the attendant doesn't get in the water with you, Michael, what's going to happen?
I would drown.
That is correct. So obviously, Michael would have to have the attendant in the water with him. And we also thought that this is focusing on the wrong issue, because the issue isn't what's happening with the attendant, but the issue is what effect is this having on the person with a disability? Because the ADA is supposed to protect people with disabilities from unequal treatment. And from personal experience, on occasion, I do act as Michael's attendant. I didn't used to, but I didn't used to get paid for it, but I'll get into that issue a little bit later. But, he has other attendants that are with him for, concerts and sporting events, etc. Now, sometimes the attendants, like myself or others, they like the event.
But for instance, my dad does not like my favorite group, so he shouldn't have to pay for it.
That's right. I have suffered through many a Dave Matthews Band concert. And the only reason I'm there is because Michael wants to go. On the other hand, I and Michael's attendants have gone to basketball games and football games, and most attendants and myself like sporting events, and so that's been a good thing. But once again, it misses the point.
Once again, we thought they're focusing on the wrong thing.
Exactly. So it's not whether the attendant's having a good time, it's whether or not Michael is being treated equally. And if he has to pay twice as much as everybody else to go to the Eagles game or the Phillies game or the art museum or the Franklin Institute or the movie theaters, then that just doesn't seem right. So next slide. So what are you going to do when you're having legal problems and you're not getting the result?
So we called our friend Steve Gold, who was supposed to be on this thing, but...
Right. So we called Steve Gold, and Steve recently retired a couple of years ago, and he was actually going to be on this call, but we had technical difficulties. And so Steve isn't here to present his part of the equation, so I'll fill in for Steve as best I can. But Steve used to work for PILCOP, or the Philadelphia Public Interest Law Center, and he specialized in disability issues. And he was working in the field all the way back in the 80s and established himself as quite an expert. And so you may ask, well, why didn't I bring the lawsuit myself?
Because he's not qualified.
Well, now, please, Michael, show some respect. But you're right, I'm not qualified. I never was a litigator. When I was in private practice, I was doing financing transactions and things of that nature. And even though I teach law now, I've never really been inside of a courtroom. So we needed to have somebody else. Now, also, even though technically I wasn't the client, Michael was the client. Since we're in the family, there's an old adage that says a person who hires themselves to be a lawyer has a fool for a client. And that's probably wise advice. So anyway, we looked to Steve Gold, and Steve served us Well,
Dad, can I add something?
of course.
Before we went after the Franklin Institute, Steve asked me to call every other museum and every major league ballpark, and they all had the same policy. So that was my first thing of homework.
That's right. So Steve said, well, let's find out what other people are doing here. And in fact, now not all places. So for example, I believe the
Philadelphia Museum of Art,
the Philadelphia Museum of Art was not charging for Michael's attendance. And how about was the zoo? Every place else. Okay. So the other thing is we also recruited. I suppose we should have told you a little bit more about Michael's personal story, but currently, since he's graduated from college, he lives in a house with two other men who have disabilities. It's a house that they own, so that they can be in charge of the attendants who work there. And
so we can hire and fire our own.
That's right,
attendants.
which is a good thing. But also, he commissioned one of his housemates, Will Keach, to go do some investigation of his own. And Will also did that and discovered the same thing that Michael had, which is that pretty much every place in the Philadelphia area had a policy that attendants had to pay. So that was the first part. The second part is Steve thought it would be wise to broaden the class of people who were bringing the lawsuit. So we didn't do a class action, but we did bring in another plaintiff, another family with child with a disability.
Also did what's the name
teamed
of
up
the
with Vision for
Equality.
Vision for Equality, and Dika Chia was the director of that group. And so they represent a number of people with disabilities. And so they would be looking for a solution to the case that would handle their needs as well. Because one of the concerns is if
you go by yourself, your case is weaker.
Because what they might say is, okay, we'll let you and your attendant in for free. And then when the next person comes along, they say, oh, we could have to pay for your attendance. So we wanted a resolution that would affect the general policies of the institution, of the Franklin Institute, and not just get relief for Michael as an individual, because he was interested in doing work that would be beneficial
for everybody.
So since we couldn't get satisfaction, we couldn't get the Franklin Institute to agree to a new policy, we officially filed the lawsuit. Now, this is the part where Steve would come in.
Supposed to come.
But anyway, in response, this is also one of the puzzling things about this, but also it was useful from our perspective, ultimately, is that the Franklin Institute decided to play hardball. They were really digging in their heels. They didn't think this was right, that attendants should have to pay. So they hired a big name law firm from Morgan Lewis.
They flew people all the way in from Miami.
Right, and actually Steve Gold had cases against these particular attorneys. And so even though Morgan Lewis has a big office in Philadelphia, they don't have ADA specialists there. So they were actually flying attorneys up from Florida to do the depositions for the case.
All the hearings.
And the hearings and the arguments. And
it took 3 years.
Right, and the whole case took 3 years altogether. But we had, so they were spending some significant money. And it also was a difficult process. And Michael got impatient at times, and he was kind of like thinking, well, is this really going to be worth it? And we said, oh, come on, Michael, think of the good things that could happen if you were successful in your case. And so he stuck with it. The other individual plaintiff actually dropped out because they were concerned about just the pressure and the anxiety of the lawsuit, and depositions can be unpleasant sometimes. They ask questions and try to make it look like it's your fault and not the defendant's fault, or that sort of thing. So,
but I was being coached for the deposition, but luckily I didn't have.
Michael, they decided not to depose Michael. They did depose his parents, as well as the head of Vision for Equality and the parents of the other plaintiff, but they did not depose Michael. Actually, I'm sure Michael would have liked to have his opportunity with the lawyers, but they decided not to do it. So the other thing is they argued for summary judgment, which means, actually they argued to dismiss the motion what they call a motion to dismiss right at the beginning before there was any evidence taken, but we managed to get through that hurdle and we proceeded. One of the other things that was of concern to us is that they seem to be sort of trivializing the
The
case.
argument was for children at the Super Bowl, everybody could go.
Right.
Not
Michael,
everybody-
Mark, I am here.
Oh, Steve is here. Oh, my
I've been muted. They put me on the attendee list. I've been here since 5 of 12.
Oh. Well, I'm sorry. Well, I'm glad you're back. Can you get your video going?
I see. I'm on okay now.
Oh, but we don't. Are you on video? I don't see you on the camera. Let's see.
I agree with you. I don't know why, but can you hear me at least?
Yes.
Sure, we can. Well, I'm sorry to.
I got to tell you guys and the members of the audience that you don't really need me. You guys have done a terrific job explaining the background and the legal theories, etc. But I am here and helpful in any way I can be.
Okay. Well, all right, Steve. Well, let me just say this. When I mean, you're welcome to chime in. If you want to just wait until we make a big mistake, feel free to chime in at that point. But
You haven't made any so far.
Well, I have been trying. Okay. All right. So anyway, as Michael was saying, they were making arguments like, well, you know, if you're a child and you have to come to a museum and you can't go by yourself and your parents have to bring you, typically the parents have to pay as well as the child. But this isn't about children. This is about people with disabilities. And everybody knows that children require special assistance, as do people with disabilities. Sometimes museums make special provisions for children and they have family rates and things like that. But they don't always do, and they don't have to, because there's no law that says you have to make accommodations for children in this respect. But for people with disabilities, you do. And then they were making arguments like, well, you know, everybody wants to go to the Super Bowl. And Michael certainly can relate to that. He definitely wants to go to the Super Bowl. But once again, this isn't about getting things that you wouldn't ordinarily be able to get. Some people tragically can't even afford to go to the Franklin Institute. But Michael wasn't saying he wanted to get a free admission to the Franklin Institute.
I said I was willing to pay whatever cost it was. I just didn't want to pay double.
Just didn't want to pay for his attendance. That's correct. And so their arguments were not especially strong at that point.
There?
Oh, well, of course.
One of the main arguments, the judge said, well, first of all, the judge said, do you know how many people will come in? And they had no evidence of
all right.
that.
So here's the main point of the litigation, or the main defense, if you will. In other words, if you bought the legal theory that what was important was not did the attendant benefit, and therefore should the attendant pay, but rather what was important is the person with a disability getting equal access. And if that requires the attendant get in for free, then so be it. So if you accepted our theory of the law and how it should work, then the whole business about people getting something for nothing, attendants getting something for nothing, didn't really hold water. So the other major argument that the Franklin Institute could make in the case was that making this accommodation, and this is typically what, changing rules, changing how you operate in order to provide equal opportunity for people with disabilities or equal access. You don't have to do that if you can show that it would create a significant burden on you. And so that's why sometimes, like if
a restaurant is inaccessible and they don't have room on the sidewalk to build a ramp, they can get around that.
That's right. So in other words, sometimes you've seen restaurants that have a couple step entrance and you might go, oh gee, how come they don't have a ramp into this building? Well, it might be that the sidewalk is so narrow, it would be so expensive, it would block other stores if you put in a ramp, etc. So in other words, if it becomes too inconvenient or too expensive, then you don't have to make the accommodation. There are many older sporting venues or many older theaters which haven't had to make some of the physical accommodations that new stadiums and new theaters have to make for people with disabilities, because it would be extremely expensive to pay for all those renovations. Often they'll make some other kinds of
Like at Frederick
modifications.
Stadium, they add the seats in the back.
You know, they'll put some seats in and they'll maybe give you a break on the price or whatever, but they're not required to do everything that a new stadium might have to do. So in this instance, if the Franklin Institute could demonstrate that they were having, that allowing attendance in for free would be a significant burden on them, in other words, cost them a lot of money, then maybe they would have an argument for saying, we don't have to make this accommodation. The difficulty, of course, is that, first of all, the Franklin Institute had no idea how many people with disabilities were coming to their museum with attendance. So and the burden is on them to show this significant burden test. That's there for them to have to do, not for us to prove it isn't a burden. So they didn't have any clue what that would be. And so that was their major problem from that point forward. They kept saying, oh, this is going to be so expensive and it's going to be so costly, and that they had no information.
We also, guys, reviewed several years worth of attendance and how many people in wheelchairs actually came in.
Right. Do you remember the numbers?
I don't remember, but there were very few.
Right. I mean, I had forgotten that they even had some numbers there. But so.
Oh yeah, there are thousands of pages of attendance reports.
Well, I'm glad that was your job, Stephen, not mine, to look through those.
Right.
So anyway, so that was their problem throughout. Now, at one point, they finally realized that maybe their case was not a winner, so they made a settlement offer. And the settlement offer,
decided not to settle.
Ultimately, Michael, I mean, we could have settled the case, and Michael decided not to. And it was kind of a provisional settlement. So what they said is, we will, for the next 2 years, we will allow attendance in without having to pay. And then we'll collect data, do an evaluation, and see how much of a loss this would be for us. And,
but they never agreed to let attendance into the IMAX, just the general.
Yeah, that's right. So this was also the other issue. Good, thank you for bringing that up. So in addition to the these general admission and the special exhibits, like
I wanted to go into the I Spy. That's what
the I Spy special exhibit. What was that about?
It was about. But that's what generated this whole lawsuit, was they wouldn't let me go in for attendance for free
To
with
the I Spy. That's right. So that has something to do, I think, with technology for the spy game and surveillance and different kinds of things. So, but anyway, so there was that, and then the IMAX theater. So one reason that this is significant in potentially other venues is that for general admission and even for special admission, most of the time, they can't even show that they're losing money. So in other words, even if they let the attendant in for free, if they didn't let Michael in with an attendant, he wouldn't come at all. And the attendant probably wouldn't come to the museum by his or herself. And so essentially, they're not losing any money. The only time that they would really lose money is if there was some limited capacity. So
correct. And one of the things,
special exhibit. I'm sorry. So go ahead, Steve.
We reviewed, months and months and months worth of IMAX attendance reports, and there were always empty seats available.
Right. So
especially at the top of the theater where the ADA seating is.
Exactly. So they had a whole row at the top of the IMAX for wheelchairs, and also they would have folding chairs for attendants to sit next to their client who was using a wheelchair. So yeah, so in other words, they're never sold out, so they're never seats that they give away for free that they could otherwise sell to somebody else. Now, where that could be more significant is
at a sports game, like a Quad Eagles
like
game.
An Eagles game where they sell out. So if they do let the attendants in for free, they're actually losing some money. However, even in that situation, the fact that they might have lost, 50 tickets worth of revenue out of 70,000 for the entire stadium probably wouldn't rise to the level of being a significant burden, but at least it's a little bit of a different issue. But
Correct.
they could not make that argument even for their IMAX movies. So because it was probationary, because it didn't apply to the IMAX theater, and it wasn't going to be a permanent solution, and they reserved the right to start charging for attendance if they decided that there were too many people getting in for free, we decided not to accept the settlement. And so the case went forward. It was, it was submitted on the discovery material, the deposition material. There was no hearings in court. Michael was very disappointed that he didn't get to testify. But basically, after about 3 years, we got an opinion from the
Judge McHugh.
Judge
He
McHugh
was wonderful.
from the federal district judge in the Eastern District of Pennsylvania, George McHugh, and we won a pretty much complete victory.
Could I add something? In a way, I wanted them to appeal so we could get more broad, but because we need somebody like me to argue with different states and all that.
Okay, we'll get to that in just a second. So anyway, one of the ironies of this kind of litigation, and Steve is, of course, well aware of this, is that if you want to have a decision that changes the law and changes the rules for people, you need a defendant that is not especially sympathetic or cooperative. Because, as I said earlier, it would have been very easy for the Franklin Institute, instead of spending all this money on their expensive legal representation from Florida, to simply say, okay, we'll let the attendants in. And a few years down the road, if suddenly it turned out that, oh my gosh, every other person here is an attendant, we're losing our shirts on this, that would have been, then they could have argued, this is a significant burden on us and we should be able to start charging for the attendance. But they didn't do that. And so because they didn't, we got an opinion, and we got an opinion from a judge, which others can read and can potentially persuade other people to view the law in the same way. The other issue is that if they had continued, and as they initially threatened to do before they reached the
Bad
settlement,
press by the Action News and Daily News, they got murdered on the paper.
that is also the other part of this, is a good lawyer would counsel their client to say, with respect to public relations issues, and they got some very bad press coverage for trying to keep people with disabilities away by charging extra. So they got hammered in the local papers and on local TV and stuff like that. So
it's really important for people to know the Daily News gave an entire front page picture of having Benjamin Franklin in a wheelchair, and they said something like, Benji cares or something.
Benjamin.
No, Benjamin.
Yes, that's it. Thank you. And they did get killed. They did get killed with that.
Right. But for instance, if they had insisted on continuing and appealing the case to the Third Circuit Court of Appeals, we might have been able to get
it. That would have been better, because I was hoping for more states to do it.
Right. We might have been. Oh, by the way, you should probably be advancing a slide somewhere in here. Go ahead, Megan. New slide. One more after that. Sorry. Next slide. Okay. All right. So we're talking about this. So
as a result of this wonderful decision, the Eagles and Phillies and almost every institution around the state and
around Philadelphia.
Around Philadelphia. I didn't mean to say around the state. I want to work on Pittsburgh. That's my next step.
What have all these other places done?
Agreed to not charge for attendance, so I've been able to go to playoff games and season ticket holder for the Phillies and Sixers, not have to pay double.
That's right. So it has had. So remember, we did this pre-lawsuit poll where the Phillies and the Eagles and the movie theaters and the other museums were all charging for attendance. Now almost all of them, and even some in Jersey across the river and Camden and such, have changed their policies now, so they no longer charge for attendance. And so for people with a disability often have limited incomes.
So this is a picture of me at the Eagles playoff game versus the Seahawks, and me enjoying the Phillies game, and also people in wheelchairs at the Philadelphia Museum of Art.
Yeah, so it has made a significant difference locally. One other aspect of this opinion, I guess, that I should mention is one of the concerns, of course, of
is what people try to take advantage of.
That's right. One of the concerns that various organizations have is that people with disabilities or without disabilities will try to take advantage of this, or people who don't need an attendant. So, for example, you don't even need to be in a wheelchair to require an attendant. You might be a person with intellectual disability, or you just might need you might have vision issues, and you might need somebody to help you around, guide you around, etc. So, and it's not always obvious that a person does or doesn't need an attendant. There are also many people who use wheelchairs who are perfectly able to take care of themselves. They're able to transfer themselves in and out of their chairs, in and out of cars, etc., feed themselves, go to the bathroom by themselves. And so they don't really need an attendant. So the concern that these businesses have is that folks will pretend to need an attendant. And under the ADA, they're somewhat limited in terms of the investigations they can make because of privacy concerns as well. It's like, do you really need this person? Is this an attendant that you can't do without? And what is your disability? And that sort of thing. So they're concerned that they might be taken advantage of. So one thing that
But you know what I'm happy about? I don't mean to interrupt this, Dad, but ever since the 80s, I don't know if this has to do with my lawsuit, but ever since my lawsuit, I've seen more people out with attendants. So I'm happy about that. People out with attendants.
All right, so maybe it's had an effect in that way. But anyway, one of the things that the opinion from Judge McHugh said is that the holding is limited to people who require an attendant. And I think the language that he used in the opinion was an attendant who was publicly paid for. So the idea is if you have a disability and your disability is significant enough, then you are eligible to receive attendant care services under the disability programs in your state. And so that's a way of sort of limiting it. So if you don't need an attendant, you won't be able to get approval to have an attendant, and therefore it'll be difficult to sort of abuse the system, as it were. But just as a personal story, that affected me because after this decision, like we were going to a Dave Matthews Band concert at the Mann Center.
Yeah.
And since, so they had adopted a policy that attendants didn't have to pay, but you had to be a registered attendant who was being paid for your service. Well, for this particular concert, the attendant who was going to take Michael called out at the last minute. And so I filled in. And so I went to the box office and I said, I'm here to pick up one ticket. Yeah, pick up the tickets. And the person was like, okay, and I need the attendant ticket as well. And I said, well, are you a paid attendant? And I said, well, no, I'm his father. His paid attendant left. I'm just filling in. I said, well, I'm sorry, you have to be a paid attendant. I said, look.
He held us up for 10 minutes.
That's right.
So people actually offered us their free lawn tickets.
Yeah, there were people in line who were saying, geez, maybe you can have our tickets. So finally they gave in and let me get Michael's ticket, his companion ticket. But I decided, all right, I didn't want to put up with it anymore. So then I registered to become an attendant for Michael, and I went to my training, and now I am an official attendant. So I won't.
That's terrific. I never heard that part of the story, Mark and Michael.
Well, there you go. So that's why I ended up becoming a registered attendant for my son. But let's have the next slide, please, Megan. Oh, I didn't know this was here.
The article.
This is the article from the newspaper. As you can see, this is bad publicity. It says, it goes without saying that if your institution is named for Benjamin Franklin, you shouldn't engage in practices that would make America's founding everyman puke with revulsion on his buckled shoes. So it's pretty strong language, but there you go. And it gives you a feeling if you read that for exactly what they had to say.
And as I reiterated, the next steps is I would like somebody from another.
1 second, please. We have to try to get back on track here. Next slide, Megan, please. Thank you. All right, so I'll do the legal part and you can do the other part. So the problem with this particular case is that it's a decision by one trial judge at the federal court. And as such, it is technically not a binding interpretation of law on any other court, even on district courts in the Eastern District of Pennsylvania. All it can be is persuasive. In other words, you look at the opinion, you look at the way the judge analyzed the language of the opinion. If other cases were to arise elsewhere, they could find this language and this reasoning persuasive. However, they don't have to. And if you, for example, want to talk to like the Pittsburgh Steelers or
which I did.
Which you did, that's right. Or the Pittsburgh Penguins or the Pittsburgh Pirates. There you go. All of, and
the attendants still have to pay.
Attendants still have to pay. So it's not persuasive whether you file, it's not necessarily controlling, I'm sorry, whether you file a lawsuit or you haven't. So in order for this decision to become effective in more areas, what we need is people like Michael to bring additional lawsuits. And if they do, and if the people they're filing suit against are sufficiently intransigent, then maybe we can get an opinion and maybe we can get some precedent established elsewhere. Ultimately, the goal would be if there were a number of decisions, and even if some of them were conflicting, we might then get another level of courts to say we would like to take an appeal and decide this on a broader basis. So if an appeals court, like the Third Circuit, if they were to reach a decision on this case and decide that attendants shouldn't have to pay, that would be binding on all of the states that are covered by that particular circuit. So I think the Third Circuit is Pennsylvania, New Jersey, Delaware, and the Virgin Islands. So
can I add something? I forgot what I was gonna say, but what I
well, when do you want to think
what I know.
Okay.
What Steve Gold asked me to do is my ways to other sports teams. So we threatened them, if you don't do this, we'll sue you. So now I don't have to pay for any sports tickets or anything for my attendance because they didn't want to get sued.
Oh, so you mean in Philadelphia?
Yes.
All right. So sometimes you might have to, when you have your discussion, say, well, you know, we might want to take this to litigation.
Which I have before, and they said, okay, no, I gave them the opinion and they backed down.
Right, so that's something that other people can do. You can say, look, we have a federal case on our side, and sometimes that can be helpful, but you never.
And all the time for me, it's been effective. But
well, not in other places.
Yeah, but
so anyway. That's basically the goal. And to us, and I know to Steve, it's been surprising that there, at least the last time I checked, which was fairly recent, there have been no other cases decided by the courts on this particular issue. And we know there are many, many people with disabilities who use attendants and require attendants to go out and participate in the community and in community events. And so it is somewhat surprising to us that this hasn't happened. And so we're just hopeful that more people will be inspired to try to change the policies in their states. Or you might find alternatively, and also this is a question of you know, not, making assumptions. You may find that there are areas in your, there are businesses or museums, et cetera, in your area that don't charge for attendance. And you might have been assuming that you'd have to pay twice, and maybe you don't. But certainly call ahead and find out. And if they want to charge you more and it makes you upset, try to take another
send
step.
them the opinion. That's what I would do.
That's
Is
right.
send.
I also suggest that Michael and Mark and Vicky, since this is being Zoomed, I assume it's also being videoed. Send it around the country. I mean, it's very easy to do the link and send it around, even though I had trouble getting on today. And to every Centers for Independent Living all over the country, that they should be doing this. This is a really easy, that with the decision by Judge McHugh, lawyers throughout the country and can just basically take this decision and run with it.
So let's take the first question.
Oh, well, so we were told, Megan, there were some
Yeah,
questions.
I was, so thank you all. I mean, Steve, Michael, Mark, this was just great information. I appreciate getting kind of all the behind the scenes of what's going on. We do have several questions from the chat box, and I want to make sure we get to them.
Okay.
The first question, I think, should probably go to Steve, and this is from Tia. And the question is, for people or for places that did not have to have accessibility built into their design, would they have to remodel their place to make it accessible? Are there requirements in terms of remodeling for accessibility? I think that's
the answer is yes. It's not a blanket yes. It depends on how much money is involved, how readily achievable making it accessible would be. But don't forget, guys, in a few weeks, we're celebrating the 30th anniversary of the ADA. All these places that have inaccessible facilities, if they've made any modifications and any renovations and anything like that over the last 30 years, that was the opportunity for them to do it. And therefore, in my opinion, unless it's just architecturally impossible, you can make it accessible readily.
great.
So the answer is yes.
Excellent.
Oh.
Mostly.
The and second question I had, or that was placed here by Maria, she's specifically asking about like restaurants. Do we have to pay for an attendant's meal, and how that kind of works within that interaction?
The answer I would say would be yes, because
yeah,
they're actually eating at the place. So the answer, my interpretation would be yes.
I agree with Michael.
Right. And I'll just say I agree too. I guess the idea is, for example, if you had a cover charge at the restaurant, or if it was like some sort of a bar with entertainment
Correct.
or something like that, you shouldn't have to pay for the cover charge. But when they come there, they don't have to eat. So that's an example. I mean, when the attendant comes,
They can just ask for a glass of water. They don't have to pay for the glass of water, obviously.
right. But it's like, if the attendant comes to like a sporting event with you, or comes to the movies with you, if they want to get popcorn and whatever, I mean, that's going to be on them. It's just the fact that they don't have to pay for the admission itself, because they do have to come in to be with the person with the disability. I will say sometimes some places have tried to adopt some fairly punitive kind of things. It's kind of like, well,
they have to look the other way.
It's almost like maybe you'll have to go stand somewhere where you can't see what's going on or something, which is pretty sad. But anyway, but as far as eating goes, they would have to pay. So, yeah.
Great. Thank you all for answering that. Another question Maria had, which is a Riverview Theater asking for attendance ID, and if that is legal.
Well,
That's it.
Steve,
Wait,
can you
Michael.
answer that one?
Yeah, go ahead, Steve.
I'm not sure it's legal. I'm not sure that the Pennsylvania Department of Human Services actually issues a identification. Many of the places like Liberty Resources do give out a card to their attendants saying that they are a paid attendant and identifies them as such. I think the reason that the review or other places might do that is the same reason that when Mark said, you know, they're worried about people coming in who are really not attendants. I think probably to be on the safe side until we really, really, really change this culture, I would have your attendant have a card.
Right, and this was an issue. It has been an issue.
In the beginning, we had
it was.
We were Steve Gold's phone number and showed them this card. Before I had ID cards, we had this representative card.
Right. Well, that's sort of a different approach.
Yeah, that is.
But Steve's point is correct that there are some agencies that don't even give out cards, and there is no standard card that, you know, if you are an attendant in Pennsylvania that you have. Now, you know, most of them will probably have a card that just identifies them as an employee of that particular company. And so that's, in most cases, that's the best that you can do. But yeah, it's on the safe side. I would, you know, try to have some kind of ID.
I've actually had to fight with the Eagles because for half an hour once because they insisted for a card that nobody has.
Right. So yes, there's been an education process for some people in terms of what's a card and what's acceptable and all that kind of stuff.
The other thing about that is I think that the person with the disability should call ahead and explain that they're going to be coming to whatever the event or the venue is, and they're going to have an attendant with them who is a paid employee. So please make sure that you have a free pass for the attendant. So that if there's a problem, you're not going to be standing listening to the music for the band you guys were talking about outside.
In my case, Steve, that would have been okay, but that's another story.
I'm gonna have to fall on Michael's side on this. That's a very important, you know, aspect to get there, get it ahead of time. Really, one other kind of piece I've been asking and thinking about is, you know, so say people are tuning in, hearing this information, saying, hey, and I'm seeing in the chat box, Michael, they all want you to come out to Pittsburgh. And they're
going to drive out there. I'm going to just give me a date when the COVID is over and I'll see it. I'll drive out there. I am.
So for people that really want to take this next step and, you know, kind of challenge some of these challenge these rules, challenge these policies, this discrimination, particularly having a case, where do they start?
I think they start by going to their center for independent living and getting the advocates from the center on their side and identifying the venues and the nonprofits and the museums, et cetera, that people want to go to, and do exactly what Mark and Michael did first. They wrote a letter and they explained what was going on. And I think Michael's suggestion about including the district court opinion is a great idea. And but I can understand why a lot of people with disabilities may not want to take this on themselves at the beginning. But the Centers for Independent Living, that's why they're there. Erie, Pittsburgh, Washington County, Harrisburg, you know, Scranton, all those centers should be doing this.
Oh, and Steve, do you also happen to know, have any contacts with people in like Pittsburgh or Erie?
I used to, I don't anymore.
Okay, in terms of disability representation.
But you guys can call up Tom Earle, who is executive director of Liberty. He'll know them.
Okay. Oh, by the way, I believe a link to the opinion in the case has been included somewhere. Is that correct, Megan?
Yes, so a link has been included in the chat box to the decision itself. We've gone through the questions and we're right up against the time. Stacy McBride is letting us know that Disabilities Option Network is in the Pittsburgh area. They may be a resource to connect in with. and talk about these issues. Michael, I'm profoundly impressed with all the work that it takes to get this in place. And I want to thank you for putting in the effort, because I know this has a national impact. I just want to thank, all of you for spending your time with us today. If there's anything else you wanted to add here at the end, I'm going to go ahead and turn it back to you. And thank you all for joining us. Go out there, challenge these in your communities nationally.
And don't forget to register to vote.
That's right. That's right.
And I want to add one more thing. I would be willing to drive out to Pittsburgh to do something, because I have some friends in Pittsburgh and I want to do it east, west, wherever. I'm willing to drive out there. Need be.
Although he has to speak with his driver on that issue. Steve, any last words?
Steve?
Oh, he might. I think you're muted, Steve. All right. Well, anyway, I think we're done then. Thank you all for the opportunity. We appreciate it very much.
Thank you very much.
Thank you all. Have a good day. Be well.
Have a very good day.
All right. Bye-bye.
Bye-bye. Okay, still.